Hi, English 149. This is Grant. I hope you had a great first week. So we're going to kick off week 2 here with a lecture on intellectual property. Now, ironically, last week, the second video was flagged for copyright infringement, which I was able to invoke fair use on. So you might have not seen the second video from last week. I was able to win the dispute, and so that video is up. So if you haven't watched it, please give that a nice little watch. And that's also to say, you know, if there were any forum posts or activities that you did not complete from last week, please complete those as soon as you can. Also, almost everyone has emailed me with just some ideas of what you're thinking about for our final video, you know, whether or not to do a video on a particular fan fiction or fan fiction group or writing your own. So please, by the end of today, please just make sure that you email me. If you look at last week on Friday, that'll give you some of the details. So anyway, with last week's copyright supposed infringement, I think this is a really good starting point to talk about what is intellectual property, right? All right, and so we can't talk about intellectual property without talking about copyright. And, you know, there is a good reason why I said this class was copy wrong. So let's go into kind of what copyright means, how it's defined. I'm hopefully going to give you just a few court cases which are going to help you understand how it's enforced, because we can talk about, you know, the philosophic concept of copyright, you know, and I'm one of those people that believe once you put something out in the world, like, everyone kind of remakes the same stories. There's a bunch of literary scholars that kind of say there are 7 stories that we always tell, and we're just telling them over and over again. And so there's a level of abstraction. And a couple of these, you're going to see the jury ultimately decides what is derivative, you know, what is too similar to something. And so I think we have to kind of take those, you know, measures, because a lot of times we want these real easy objective measures and we're not going to get them. Okay, so copyright is all about protection of expression. Okay, so there's not really protection for ideas. Ideas are really covered under patents. Okay, so you know, if you have a particular story and you know, express it in dialogue, right, and then someone goes along and expresses some kind of story in narrative form, that's going to be different. Okay, so we're talking about protections on expression, and we're going to get into a little more of what that means. But just in general, if it's an idea, it's going to be a patent. If it's an expression, it's going to be copyright. Another one is fair use. So I invoked in that last video, I am not only commenting on the video, it is for academic purposes, and academic purposes covers a lot of copyright use. And so as an instructor and as a critic, I can use copyrighted material as long as I'm commenting about it, or as long as I am using it for academic purposes. Okay, so independent creation. So, you know, a lot of times if someone doesn't have access to something else, and, you know, like, say you just randomly come up with something and we as the the court can decide whether or not you had access to something that's very similar, right? So people that aren't familiar with your work, that don't use it, but if your work just ends up being similar, that's covered. Okay, so if you don't know about something, like, don't worry about it. As long as you're not thinking of it or had access to it, you're going to be protected. And then compulsory licensing. So this is to say, like, you can't completely shut down. You can't use my work at all, right? Like, you have to be able to either give people the ability to pay for using images or text, right? You can't just deny them completely. So that's what compulsory licensing means. Okay, so there is a requirement for copyright to be original, and so it's a really general term. So what is originality, right? So it's three things. It's going to be highly creative. So again, these are definitions that the court decides by reading this stuff. So how creative is something? We tend to think of really taking a text and changing something fundamental about it can be a highly creative act, right? Is it valuable? Is it useful? Is it, like, honestly, popularity falls into this too. So, if it's a work that's in question but becomes extremely popular, that can also be a defense against copyright. And then something that's never been done before, that's easy for originality, right? It has to be new, it has to do something new, it has to be novel in some way. All right, so let's get into our first case about what is original. So the case we're going to look at here is the 1991 Supreme Court case Feist versus Rural Telephone Service, which involves phone books. I don't know if some of you have seen a phone book before or used them, but they're listings of people and businesses, right? And Feist published a phone book which included listings copied directly from Rural, and then Rural sues for copyright infringement, right? They're like, oh, you copied our information. Now this is going to get into like a sweat of the brow problem. So even if you put a lot of work in, there's going to be something called facts, and you really can't copyright facts, okay? So facts, non-copyrighted, right? You can't find something new and say that's mine, every time you say it. You need to pay me or you have to use it. So facts cannot be copyrighted. Now fiction, of course, is copyrightable. Now there is a in-between area of these two, and we call them complications. So these are things that can be copyrightable for the selection and arrangement, not the facts. And so in this case, Feist versus Rural, they're arguing that the name and phone number are facts, right, in a telephone book, but their arrangement and selection are copyrightable. Okay. So again, individual phone listings are facts, not protectable. The selection and arrangement is not protectable because it lacks originality, right? They're entirely typical. They arrange the phone book in alphabetical order. Alphabetical order is not copyrightable, right? If there is some kind of grouping that's original, then sure, that can be protected. But putting facts in a very typical order like alphabetical is not copyrightable, okay? So this is kind of one of those good cases where we decide, what is copyrightable, that, facts are not copyrightable, and the arrangement needs to be unique, right? You can copyright something like a phone book as long as the way in which you're organizing, like you could say, oh, I'm organizing this by people I like more than other people, then that's original. All right. So other kind of use cases in the same copyright would be like coding systems for medical procedures, parts numbering systems, listings of car values, prices of rare coins. So these would seem like facts on the surface, but they're not. Like, car valuations can be pretty subjective, and there's different criteria someone could do for rare coins, or parts can be numbered in a number of different ways, so that can also be copyrighted. Okay, so again, it needs to be an original version of organizing facts. All right. There is a kind of, axiom in copyright law that there needs to be a fixation in a tangible medium of expression. And this is protection only for communication. We use evidence here. And a lot of the times it's for stuff like, your iPhone menu and the way that your iPhone works. Can you copyright menus on OS operating systems, right? And as you can kind of see in the difference between iOS and Android, there are very specific expressions. You can't copyright menus, right? But you can copyright the way those menus get laid out, right? And, if these are things just to communicate, they have to communicate in very specific fashions. And this has implications for things you do, take photos, write emails, those are copyrighted. Right? You are creating something for communication. They're fixated in an email, in an image. So those things are all copyrighted material, okay? Because they're also communication. We have evidence that it happened, right? It gets saved on a phone or a server, okay? So, yes, moving on. All right, so a little more about ideas versus expression, right? Again, these kind of tangible mediums are all about how the idea gets expressed, okay? And those are unique. So copyright protects expression, again, not ideas. So an idea is covered under patent law. So Baker v. Selden in 1879, another famous case. Selden wrote a book on double entry accounting, which I am not familiar with accounting, but it's still used today, I guess. The book included example forms for using the method. Now the court ruled that there was not protection for the forms because they are the manifestation of the idea and not the expression, right? So these forms were in the back of this book, and all they were doing was they were basically talking about the way that this form would go, and then they're just creating what the form is. So there's these weird lines between what is the idea and what is the expression. And, I think the concept of manifestation of the idea and not the expression is really interesting. So a form tends to kind of take that route. But a complication to this is a cookbook. The individual recipes in a cookbook are not copyrightable, but the arrangement of those recipes is. So the recipe book is copyrightable, but the individual recipes are not, because they are instructions. They are kind of like, when you think about this accounting form, right? Recipes are a manifestation of the idea and not the expression, right? The cookbook is the expression, the recipes are the ideas. Cookbook, copyrighted, recipes, not. Okay, so again, these are all have to do with levels of abstraction, right? There's the idea, there's a general description of the idea, and there's the specific expression of the idea, right? So another case is Morrissey versus Procter and Gamble. This was on contest rules, and basically it was Morrissey was trying to get protection for contest rules that they wrote for Procter and Gamble, and because they're kind of procedural, like an accounting form, like a recipe, this is again when the idea merges with the form, right? They become kind of tied together. So again, when I talked before about menus in an OS, right? The specific menu you can copy, but the way that it's expressed, you can't. All right, so copyright, kind of zooming out again, covers the kind of following things. Like when you create something new, this is what you get the rights to. You get the rights to reproduction. You get the rights to create derivative work, which can include adaptations that are distinct from the source material. We'll get into what that means, because I think that's really important for this class. Distribution. So, if I have a publisher publish a book, many times that particular printing of that book is the publisher's copyrighted, not mine, okay? There's performance and display, right? You have control over how your piece gets adapted into a movie, if that's what's happening. You have the right for anti-circumvention, which is, people that remove DRM or encryption. You can go after them for that. And then you have limited, not completely, but you have some moral rights over, people using your art or stories to kind of do harm, right? People can use them in different ways to comment, but if there's violence involved, you're protected against that. Okay, so what happens when someone infringes on your copyright, right? So there's copying, right? And it needs to have direct evidence. You need to prove that you have access to the work, and there is a, quote, substantial similarity, right? So this is where reading text and saying, is the setting, characters, plot enough to say that's so substantially similar, right? And think about those originality, like how original, how creative is it, right? So Arnstein v. Porter, 1946, this is where the Supreme Court decides that a jury can decide whether similarity is close enough, okay? So we read the text together as a society and we decide. So there's no hard and fast rule on this stuff, right? This is like a jury of your peers decides how similar something is. The second is improper appropriation, right? Not all copying is impermissible, right? And this is like where you have certain elements that are copied and some aren't. And so you can go about this two ways, right? You can look at the protected elements that are copied, right? If someone uses character and setting, we're going to just look at those similarities. Or are you going to look at both the protected elements against the new elements, right? So there's different ways that these are often judged. Obviously, judging everything holistically seems to make a little more sense, but there has been rulings in the past that look at the copied elements and make the judgment on that. Now, there are things that definitely have less protection, like I mentioned software here, because a lot of the times different pieces of software are very identical in their coding, right? In their, especially if they're using open source language, right? And so, you know, near identity is required, and that's where it's hard. Software is becoming increasingly difficult to think about with intellectual property. All right, so derivative work here. Here's a mustached Mona Lisa. So a derivative work is a work based upon one or more pre-existing works consisting of editorial revisions, annotations, elaborations, or other modifications, which as a whole represent an original work of authorship, is a derivative work. Okay, so that's a lot of legal jargon. A work based, not based, sorry. Right, we want to look at editorial revisions, annotations, elaborations, or other modifications as a whole, okay? So here's an interesting case. Anderson v. Stallone, okay? This is sort of recent. So Anderson created a small script based on characters and plot lines from Rocky 1 and 3, right? And Stallone takes a look at it, and then they end up making a Rocky 4 that is very similar to this script that Stallone saw. Okay? And the irony of this case is, yes, there is infringement, but Anderson doesn't own the copyright. Because Rocky 4 is derivative, only Stallone has the right, because he owns the copyright to Rocky 1 through 3. He has the right to Rocky 4. So it's not Anderson who has the rights, it's Stallone, okay? So even though Anderson wrote the script, he just basically reused a lot of the plot lines and characters from the first 3 movies. So the court used character and plot line here, okay? And they said those two things, because they're just a continuation of those first 3 movies, Stallone owns the copyright to it, okay? Another thing that I think technology brings onto the game, and I want you to think about this in terms of fan fiction communities, right? The famous case of Napster. So Napster was if you're not familiar with it, was a file sharing service for music. And because it maintained a central database, Napster was actively involved in copyright infringements, right? So it was people distributing copyrighted music to other people for free, right? And because they are maintaining the database, they're involved in the infringements. And so later software like LimeWire or Tor networks, right, are computer to computer, maintained. So your own computer, you're connecting to someone else's computer, So Tor or LimeWire is not maintaining a central database or server, so they aren't liable. So you gotta be careful about these things, like how involved are you or your platform is in copyright infringement. All right, so to kind of sum all this up, I wanna just get into the future. So we wanna think about, like, you know, yes, protecting copyright, but also, like, if there's hurdles to really access things like too much encryption, or is there too much licensing going on, right? You see a lot of software that you don't own that you can't modify because that company owns that intellectual property and they're only giving you a contract or a license to use it. And this gets into kind of scope of fair use. So the John Deere software, which is still kind of being decided, John Deere basically says, you know, because they have this sophisticated software on their tractors, you can't modify anything on the tractor because the software and the hardware work together. And so, like, if you wanted to service your John Deere, you have to go to a John Deere dealership. And you can see Apple's trying to do the same thing with repairing the phones, right? Right now you can only get Apple batteries to replace in your iPhone. And so we want to think about, like, well, what is the interaction between software and hardware, and can you make these intellectual property claims based on that? And then, you know, in the age of the internet, when it's so easy to copy and manipulate images, text, and music, like, what do we do with copyright? Like, how do we ensure people that create things still get money? And how do we make sure that they get credit for what they're using? Or in the age of free-flowing property on the internet, like, do claims to own something even matter anymore? Okay? So I hope this was a rather long, but I hope it was a good introduction to copyright. Please continue to ask questions in the forums and let me know if anything's confusing. I will see you tomorrow on Tuesday.